Hello, it's Philip Taylor speaking from Richmond, Green Chambers in London. I'm looking at this book today from Wildy's. It's Wildy, Simmonds and Hill Publishing, and it's a book called A Practitioner's Guide to Inheritance Act Claims. It's been written by someone called Nasreen Pearce, who's a retired circuit judge, known to many people. This book's now in a 4th edition. It's a hardback. There's the spine, and then there's the back. The actual book itself runs to something approaching under 500 pages. The index at the back is a very standard index, very much part of the structure which Wildy's have, and the references are to page numbers. And then when you look at the actual publication itself, you've got a whole series of appendices at the back. Then you get to the actual body copy, and you can see there's the paragraph numbering on the sides there to find things very quickly, and you've also got quite a lot of detailed information concerning the subject matter. A lot of case law, for instance. Just looking at it, you can see a whole series of cases cited here. It's a very erudite work and extremely useful for anybody involved in this area. There's the front page, and then after that we've got a contents section. And you should be able to find what you're doing well and navigate things quite quickly. You can see the structure of the index. The contents rather is very helpful. Obviously go to either the index or the contents section to see what you're actually looking for. You can see again the way it's actually structured. Then we get to the end of the contents section there. There are 13 chapters. The appeals are at the back as usual, and then you've got the appendices. You've got precedents, legislation and practice guidance. There's a lot of information, everything you want to know really about inheritance tax claims. Then you've got the case law, an abundance of cases of course as usual. And after that you've got the statutes, which are of course very important. Then after that statutory instruments, and then after that some international materials just to upset the Brexiteers. I'll mention that. The fact is we still have a lot of international information. Then you get to the basis of the book. It starts off with the introduction, the background. It has long been a characteristic of English law that provided a person has testamentary capacity and complies with the formalities relating to the making of a valid will, they may, in their will, make provision for the disposal of their entire estate on death as they choose, and their estate will devolve in accordance with the terms of the will. That's the basis. And then of course you've got the interference by Parliament, and this is where the political issues, because there is a political issue here, and that is a lot of people feel that the Inheritance Act should be scrapped. It hasn't been, and we are where we are. So Nasreen Pearce's book, Judge Pearce's book, is well worth reading. Now, Elizabeth was the lead writer, and she gave a headline: "A tax we should abolish?" ? Well, not yet. Meanwhile, practitioners in this area should read this book. And she then goes on to say, and in fact we discussed this, so it's a mixture of what we both thought. Lawyers dealing with inheritance tax issues, and they're out there aplenty, would be wise to acquire this long established and eminently useful title, now in a new and extensively updated 4th edition from Wildy, Simmonds and Hill. The author is Her Honour Nasreen Peace, who, as I say, is a retired circuit judge, well known to the bar and to readers of these publications and other similar ones. And she's got particular expertise in what is a challenging area of law here. The book therefore offers practitioners a detailed and authoritative guide to the provisions of the Inheritance, Provisions for Family and Dependents Act 1975, with reference to subsequent and recent legislation which is discussed and analysed in detail. Got the cases as well to go with it. The Act itself, as the author points out, has been amended over the years to meet the needs of an ever-changing global society, notably the now varied forms of family and the extension of non-traditional family, as a prime example of this being same-sex relationships. So you can see that it's had to modernise. Again, many people think, well, why should the state get their hands on this sort of money? And that's a big issue and a big political one. Usefully, of course, the book gives us a step-by-step guide to the preparation of cases under the Act and the practice and procedure required to process an application through the courts. And it deals with every conceivable aspect of this complicated area of law, which, to the advantage of the practitioner, delivers informed comment as well as a fascinating insight and reading into the Act itself. And it's supported, of course, throughout, as I said, by a wealth of references to case law. And I do find that quite helpful because you get the human involvement coming in. Also contained in this updated edition are detailed discussions of a range of issues that are relatively recent to emerge onto the scene, namely cryptocurrencies, which I wholly oppose. I think they're criminal. It's just an excuse for criminality. However, that's my view. But it's called cryptocurrencies and crypto assets, for example, and the increasing importance of, and obviously the necessity for, negotiation and mediation. But you've got the two cryptos, and then you've got the usual device of trying to avoid any long drawn out litigation in court. But I will make that point about cryptocurrency and crypto assets. Be very careful because they're very dodgy, in my opinion. But people may have different views, up to them. Now, with its detailed index and table of contents, and of course the numbered paragraphs which I've indicated throughout, the book is, I think, very easy to navigate. Do note the tables of statutory instruments, the guides, the codes of practice and international materials as well, just in case you've got an issue with that. All but one of the 13 chapters features an introduction, and the chapters themselves cover every relevant aspect of this minutely detailed legal landscape, which more often than not demands an erudite, precise and yet sensitive, because it's very emotional, this approach to what are sensitive and often complicated issues, such as, for example, domicile, time limits, eligibility, grounds for making a claim and so forth. Note too the 3 appendices at the back, which include legislation, precedents and practice guidance. So let me conclude by saying that it's comprehensive and it's practical. It's an authoritative legal text which we've come to rely on from Wildy's, and I thank them very much for producing these titles. It's long been regarded, of course, this publication as an essential purchase for practitioners involved in this particularly challenging area of law. The date of publication is 2023. It is a practitioner's guide. Let's have a look at it again. And very much in the series of what Wildy's produced, 4th edition, and you can see the spine and then the back. It's a heavy book. It's a good book. It's very much for practitioners and people who are doing things themselves with a certain amount of knowledge of the area. I've just opened it at page 200. Matters to which the court is to have regard. And again, you can see there's a whole list of points and cases just to give you a feel for what we have. Wildy's are well known now for producing these excellent books, and I'm very grateful to all of them who are involved for doing so, because they make our lives so much easier. A big thank you to everybody, and in particular to Judge Pearce. Thank you. Bye-bye.